Courts of Justice Committee will come to order. We'll open the roll and take roll. Roll is open.
Mr. Chair, you have a quorum.
All right. For any House members who are here or watching on the live stream, we're going to interview 4 candidates for the Supreme Court first and then take up bills that are identical to Senate bills, which we ought to move through pretty quickly. Once we get to that point, we will call patrons and get them down here. We have about 30 bills, 30 couple bills on the docket today. We need to move through those. We have 3 meetings, hopefully, to complete all of the bills that are before us. But first, we're going to pause in consideration of the bills and take up interviews of the candidates. Senator Stanley, would you take the chair? proceed with the docket. We have a number. Okay. And reminder for the members of the committee, you certainly are welcome to peruse the packet with respect to the candidates for the Supreme Court during the course of this meeting. I would encourage you to do so. However, please remember that these are confidential materials that you must leave here at the conclusion of the meeting. And if you need access to any of that information, you should contact Ms. Hurd in Legislative Services. We have a number of bills that we ought to be able to move through relatively quickly. And for the House patrons, I'm sorry for doing this. We will gladly call you, but we're going to move through the cognates real quickly first. We have 3 bills that passed the House in identical form as companion bills that passed the Senate. House Bill 1728, but from Delegate Reed, is identical to Senator Favola's 1139. House Bill 1922 from Delegate Bourne is identical to Senator Barker's 1627, and House Bill 2769, Delegate Ronnie Campbell's, is identical to half of Senator Chafin's Senate Bill 1166. The list is in front of you. Is there a motion to take those up in a block? It's been moved and seconded that those 3 bills be reported in the block. The roll is open. And let me strike the roll for a second. Just strike that. Before we do that, anybody in the audience wish to be heard on any of those 3 bills? Any reason we should not take those up in the block? All right. No. You've got a sheet in front of you, John. And if anybody wants them taken out of the block, we can do that. But all right, it's been moved and seconded that those 3 bills be taken up in the block. The roll is open. Clerk will close the roll. Well,
Ayes 10-0.
10-0, those 3 bills are reported. We have 2 House bills with identical Senate bills that came out of other Senate committees. They are Delegate Jones's Bill 1664, dealing with out-of-state convictions for drug offenses and restricted driver's license, that is identical to Senator Stewart's 1181, and Delegate Herring's 1711, which is identical to Senator McDougal's 1382. Unless there's an objection, we will take those bills up in a block. Is there a motion to report those bills? So moved. Senator Howell.
I'm just curious why they're in this committee if they were in, the identical bills were in transportation.
That is a question which I cannot answer, but I can tell you that they reported unanimously out of transportation. They were referred here by the clerk, and it may be that they should have come here at the beginning of session. We can certainly send them to the Committee on Transportation if that is the desire.
Mr. Chairman, I might be able to shed some light on that. Mr. Chairman, typically the clerk refers them based on our rules on the title. So if the title was in any way had a variance that might have contributed to how it was styled, even if the bill itself had no different substance.
No. No. I didn't want to cause trouble. I just wanted to know how it happened.
All right, Senator Stewart moves, Senator McDougal seconds that those 2 bills be reported. The roll is open. Who's got Senator Norman's proxy?
You do.
Oh, I do. Senator, all right, clerk will close the roll.
Ayes 14, no zero.
All right, those bills are reported. We have a number of bills that passed the Senate for which there are similar House bills. Kristen, did we reach out to each of those patrons and ask them to appear if they objected to having them conformed? Okay.
Mr. Chairman, I talked to
Senator McDougal.
Delegate Ranson, and she asked me to handle it for her if
All
possible.
right. All right. You want that out of the block, not conformed?
What were the differences?
You don't? Okay. Okay, let's take that up. House. All right, I tell you what, let's take these up. Since we're going to take them up individually, we'll take them up after we take up the patrons who are here, given the long line of patrons who don't seem to trust that our clerk is actually going to call them. We'll take Delegate Rush first. I promise you, we really do call you. We will not leave your bills in the breast of the committee.
Yeah, Mr. Chairman, and the clerk did call my office, so I really appreciate that.
All right,
Excellent
Delegate
timing.
Rush.
Yeah. Mr. Chairman, members of the committee, House Bill 2548 allows, once your rights have been restored, there's another step that you must go to get your Second Amendment's rights restored. That information is currently kept at the local clerk of court. What this bill does is also has that information entered into the CCRE so that road deputies, state police, and police officers will have that information if you were to be pulled over with a firearm.
Delegate Rush, this is a bill that we heard last year, passed out of this committee, 14 to nothing and 16 to nothing out of the Finance Committee. I think maybe it got caught up in some flack at the end of session, but I think the members are familiar with your bill. Anybody have any questions of Delegate Rush? Anybody in the audience wish to speak to House Bill 2548? Yes, sir. It's in pretty good shape, I think.
I understand.
You want to mess it up?
No, no. VCDL supports the bill. Philip Van Cleef.
That's great. All right, does this need to go to finance? It does not. It's been moved and seconded that the bill be reported. The roll is open. Somebody has Senator Edwards' proxy. Peterson? No. Okay. All right, the bill reports.
Ayes 14, no zero.
Thank you, Mr. Chairman, members of the committee.
Yes, sir. Delegate Adams.
Good afternoon, Mr. Chairman, members of the committee.
Good afternoon.
I am here to present on House Bill 2453. House Bill 2453 is a recommendation of the Crime Commission, and it follows their study of the pretrial process in Virginia. And the bill would direct that magistrates transmit to the court file the document they use for determination for the admission of bail. This is predominantly the culture, it was found by the commission across the Commonwealth, and the different stakeholder, different interest groups, I should say, the Commonwealth's attorneys, but the defense bar, they all were in favor of this additional information appearing in the file.
Are you aware of any opposition to the bill?
I am not.
Okay. Anybody in the audience wish to speak to the bill? Anybody in the audience wish to speak in opposition to the bill? Yes, sir.
Mr. Chairman, members of the committee, I'm Darrell Puckett. I'm the Commonwealth's Attorney for Appomattox County. I'm here today representing the Virginia Association of Commonwealth's Attorneys, and we support this bill.
That's great. Thank you.
Thank you.
Nobody in opposition? Senator Deeds moved that the bill be reported. It's been moved and seconded. The clerk will open the roll.
Ayes 15, no zero.
15 to 0, the bill reports.
Thank you, Mr. Chairman.
Thank you, Delegate Adams. Delegate Brewer.
Good morning, Mr. Chairman, members of the committee.
Afternoon.
I have House Bill 2170, which is known as false caller identification, or what we know as those really annoying phone calls called spoofing. House Bill 2170 would finally define in the code what false caller identification is, and also pair with that a Class 3 misdemeanor for good measure. In the Commonwealth currently, while we do have other statutes that address annoying phone calls, this is a unique situation that is relatively new. And the FCC recently is partnering with major telecoms to provide a new program that's getting released in September called Stirred and Shaken, which will provide law enforcement agencies a digital footprint.
Mr. Doucette may not want to leave. Go ahead.
Stirred and Shaken will provide. Will provide local law enforcement agencies digital footprints and the opportunity to track these individuals.
Okay. Well, I guess Steve is leaving. I was going to ask somebody to.
Mr. Chair, Mr. Chair.
Senator Peterson.
Okay. How many times have I been in the Senate chamber and somebody has a cell phone ring in Stanley's desk? And we find out it's in Stanley's desk, or somebody else's desk and Stanley put it there. Is that now a Class 3 misdemeanor?
I mean, I think that's a horrible offense.
And that does happen, by the way. That's a
does
true
happen.
story.
And so actually, to be more specific, so the false caller identification is very specific to the intent to deceive, harass, or harm. So it has a very clear standard, I think, that addresses that, unless you feel like Senator Stanley has done that to you.
All right. That was just.
Steve, can you tell us a little bit about some of the discussion and concerns raised in the work group?
Mr. Chairman, I think everybody who's looked at this bill understands the problem, and I think we have all been victimized by this sort of thing. The problem is, how do you address it? For example, the bill speaks on line 14 to data that misrepresents the identity of the caller. And that leaves us wondering exactly what that means to misrepresent the identity of the caller. Clearly, if the name appears in your caller ID as somebody else's name, Mark Obenchain shows up on my cell phone calling me and it turns out to be someone else, that I think would be a misrepresentation of identity. But what if we all get calls that purport to be from, say, Arkansas or Philadelphia, and it turns out to be a robocall or, a campaign item that clearly has nothing to do with Arkansas or some city in California. The question is that misrepresentation of identity? Or if a different phone number shows up because now we've all been getting phone calls on our cell phones that mimic our own first three numbers of our call. Is that a misrepresentation of identity? And then finally, we question, what if, the name of a business shows up and it is not in fact that business? And so we don't know. Some of these items might be misrepresentation of identity, some might not be. And because it's a criminal statute, Mr. Chairman, we were concerned about the vagueness that was worked into the bill.
I would say this, and far be it for me to sit in front of a room full of attorneys because I am not one, but I feel like that it was addressed in the Fifth Circuit Court of Appeals decision that they addressed some of those issues that I understand to be correct. And in fact, when we went through the drafting of this bill, we struck some of the words to make sure it was totally in line with that. Furthermore, not all calls originate out of state. There is something called neighborhood spoofing as well, where people intend to deceive people locally, and that's also a concern, and that would be addressed in this bill as well.
So, and how about if and I'll tell you this has happened to my firm. Mm-hmm. We have voice over IP with a vendor, and for the life of us, it took us forever to get the caller ID right. It would show up as some weird HQR or something 3715. I mean, I have no idea what it was.
The voice over internet issue is at line 27 through 31 of the bill.
Okay.
to address that
Good answer.
specifically.
Senator Stewart.
Thank you, Mr. Chairman. Delegate, as I sit here and think about this in my feeble mind, I'm really struggling with how you would prove a case like this. Because you have a spoof caller and the scenarios you've set out. But how do you know who's on the other line? And wouldn't this lead to a ton of false accusations? And how would you ever get the evidence to try a case like this in court?
I would say to the senator that, so the FCC and the major telecoms are actively working on this. Again, I said in September, they'll be releasing Stir and Shaken, which provides a verifiable digital footprint that the law enforcement community can use for direct prosecution. So that
Mr.
would be the
Chairman.
mechanism of what you would use.
Well, you can prove the phone, but you can't prove the person who's using it.
That admittedly, that would be difficult.
So if Bill Stanley, which this is very likely to happen, uses my phone to spoof somebody, now I'm getting charged and prosecuted when it was Bill Stanley.
Well, I am certain that if we do pass this bill out
That
of
gives me
committee.
a great deal of concern, Mr. Chairman.
Bill Stanley would do it.
Mr. Chairman, this is not the time for accusations such as that to be coming forward, okay?
Mr. Chairman, we had one other question concerning the intent. On line 17, the crime that.
Hang on. Line what?
It's on line 16. This is where the crime, the new offense is defined, and it addresses or prohibits a person acting with the intent to defraud, intimidate, or harass. And we weren't certain that that is the intent that the patron intended. Except because the situations we've been talking about sounded more like misleading situations, not harassing or intimidating.
So actually, in House courts, we made those fixes very specific directly because of the wording that was used in the Fifth Circuit Court of Appeals opinion. Also, it falls in line with everything that's in the Truth in Calling Act as well. And so those specific words were requested to be used.
The question, Mr. Chairman, would be what evil the patron seeks to address. Is it people who call specifically for the intent of harassing and intimidating?
With the intent to defraud and deceive. So, and I want to address the majority of the reason I'm bringing this bill is for neighborhood spoofing, but I feel like we're moving into a new area of technology where now that we have this Stir and Shaken program that's going to be released, it's appropriate that we start defining what some of these things actually are. But neighborhood spoofing is actually something that happens locally where someone may mask their number. They may say they're calling with a local volunteer fire department or a sheriff's office that's collecting donations, and they stop by and show up on your door, and they have the intent to defraud or deceive. So neighborhood spoofing, which is local community spoofing, does already occur, and there's no mechanism to address it.
All right. Charles, we were just talking about asking whether Senator Black had a bill addressing a similar topic.
Mr. Chairman, I know there have been bills introduced on this topic that take a different approach, and that approach would have been allowing the State Corporation Commission to essentially take administrative action against those individuals who might be phone spoofing or, essentially changing their numbers to commit the acts that the patron here is trying to address.
Okay.
I don't have that bill number in front of me, but I know there have been bills introduced this session with that same issue.
All right. Anybody else have any other questions of the patron? Anybody in the audience wish to speak to the bill? Okay. Bill is before us.
Second.
It's been moved and seconded that the bill be reported. Does this need to go to finance? No, we have
No
a-
fiscal impact.
I'm sorry?
There was no fiscal impact to sign.
I just see a fiscal impact statement. It does not? Okay. All right. It's been moved and seconded the bill be reported. Roll is open. Oops, excuse me. Hang on. How do I clear this? All right. Okay.
Thank you, Mr. Chairman.
Ayes 11, noes 4.
All right. Thank you. Next, we have Delegate Thomas. Delegate Thomas, I know we took up House Bill 2136 last week, and I think that there were some questions. I know that your Commonwealth's attorney for City of Fredericksburg caught up with a number of us and clarified a couple of those questions, including mine. This deals with the accident reconstruction issue. I don't want you to have to re-present the bill. Anybody have any questions concerning this? Recall the bill? Ms. Jenkins, do you have anything you want to say? And Delegate, you're welcome to say anything you want.
Obviously, representing the Commonwealth's attorneys, we support the bill.
Okay. Steve, do you have anything?
Yes, Mr. Chairman. After the presentation last week, I wanted to identify or determine whether there was, in fact, a problem that needed to be addressed here. And what was described, what I had heard is that a recent Court of Appeals decision had mischaracterized an old Virginia Supreme Court decision and essentially held that accident reconstruction testimony was not admissible. I have a different interpretation of that case. And I think although the wording may have been loose, it did not in fact hold that accident reconstruction testimony was inadmissible. Just the opposite. I've reviewed, I think, all of the cases in Virginia that concern accident reconstruction testimony. And when they have not been admissible, it's been because the expert made assumptions, for example, that weren't supported by factual evidence, that there was speculation, that the particular topic invaded the province of the jury, all factors that the rules of the Supreme Court prohibit expert testimony on. And so my opinion, Mr. Chairman, is that there is not a problem and that accident reconstruction testimony, if a sufficient foundation is laid, as with any expert, would still be admissible in Virginia.
Mr. Chair, I'm going to disagree with my colleague over here, Senator Benjamin or Mr. Benjamin. Listen, an expert witness needs to have a field of scientific study. Toxicology, engineering, DNA, okay, it needs to be a field of scientific study. Accident reconstruction, believe it or not, is not a field of scientific study. You don't get a PhD in accident reconstruction. That is the province of 7 people sitting in a box called a jury, or 12 in a criminal case. And I think when we allow an accident reconstruction expert, what we're really doing is invading the province of the jury, telling them what they, as ordinary citizens, are supposed to think and feel when they interpret ordinary, mundane facts. And so I disagree very strenuously that this is a field of expertise. I have tried civil cases where judges have looked down at me and said, "Chap, you cannot put on an accident reconstruction expert in this state." Now, that was a civil case, but it was from a trial judge who I think knows a little bit more than anyone else in this room. So I disagree, and I don't plan to vote for this bill for the reasons I've expressed previously.
Mr. Chairman.
Senator Reeves.
Just a statement, and maybe LaBravia can clear it up, but why do they teach us in the basic school and then advanced school in law enforcement about coefficient of frictions and stopping distances and whether the road was wet and what are the yaw marks and how do you determine speed of the vehicles and those sort of things if I'm not using math equations and scientific data for that?
And Mr. Chairman, the answer would be because if the party lays the proper foundation, if the expert sees the evidence and the necessary facts are in evidence, if all those boxes are checked that our evidentiary rules require, then that sort of testimony would be admissible. And there is no case in Virginia that says it's not admissible. It's only inadmissible if the party fails to lay the proper foundation for the expert's testimony. But that applies to any field of expert testimony.
Well, and my question would be, do you have any concern that, as worded, this eliminates the foundation threshold? It says when properly qualified. does that somehow lower the threshold for the foundation?
Mr.
for
Chairman,
expert
it's a good
testimony?
question, but you're focusing on the wrong wording. When you speak about an expert being qualified, that only means that they have the necessary education or experience in the field to testify. What we were talking about was whether the expert, for example, is
I know.
basing his opinion upon facts and evidence, or whether he is offering an opinion on one of the ultimate issues at issue, or whether he's speculating. And those are prohibitions that are found within the rules of the Virginia Supreme Court. And so, ironically, the bill does not do anything because it says this testimony is admissible subject to the rules of the Supreme Court. And it's the rules of the Supreme Court that in every case I ever viewed have been the reason that the courts have held that that particular testimony was not admissible.
Gotcha.
Mr.
All
Chairman.
right, Senator Pete.
Question to either the patron or Madam Commonwealth's attorney. I mean, is there a particular case that where this was a problem or a specific issue? What was it?
Mr. Chairman and senators, I actually sent an email to all of you which listed the cases in Virginia where the court actually said that there was no right to have traffic, an accident reconstruction expert testify.
Mr. Chairman.
Sir,
Yeah, because I believe that's the current rule. But did that prevent them from getting a conviction in any of those cases?
Well, it did lead to overturning some of the convictions in the cases.
Because they allowed, the Supreme Court disallowed.
Senator Pete.
Yes,
Mr.
and.
Chairman, thank you.
I'm sorry.
Yeah.
Mr. Chairman, there is another case where actually accident reconstruction testimony was admitted, but the only reason that the Supreme Court upheld the conviction was because there was a waiver. They considered that the defense waived their right to object to the accident reconstruction.
So, Mr. Chairman, I would confirm what Mr. Benjamin said and Mr. Peterson then, that the Supreme Court has said there is no accident reconstruction in these cases, and therefore you're bringing this statute to overturn the Supreme Court.
I think it's
Well,
circuit courts.
not to overturn as much as to clarify that accident reconstruction is not junk science, that it involves physics and mathematics, and that there are many accreditation agencies which allow these people to be experts in the field. And 49 other states have agreed that accident reconstruction testimony is admissible.
Mr. Chairman, let me make 2 points. Number one, and this is important, I have found no Virginia case, and this is responsive to Senator Peake's question. I have found no Virginia case that holds that accident reconstruction testimony as a field is not admissible. You have to do it right. And in the case that I understand created the concern, that's the Chavis case, a 2017 case. In that case, the expert was permitted to testify as to the data extracted from what we would call the black box. He was permitted to testify to that, but he wasn't permitted to give a conclusion as to the speed of the vehicle before the accident because it was agreed that the condition of the brakes the tire size could affect the accuracy of the black box data, and the tire size was not in evidence, and so that wasn't permitted. But that's just basic principles and rules of the Virginia Supreme Court. If you do it right, then you can have your evidence admitted.
Mr. Chairman.
All right, Ms. Jenkins, we're going to have to bring this to a close. I think Mr. Benjamin's view is that this really doesn't do anything. It does no harm, but does no good. Senator Stewart.
Mr. Chairman, it may help some circuit court judges who may not have a great handle on it. Well, sometimes you have to. And at any rate, Mr. Chairman, I'm going to move the bill be reported.
All right, there's motion properly seconded to report the bill. Roll is open.
Ayes 5, noes 10.
Thank you, Mr. Chairman.
Sorry, Delegate, nice to have you. Better luck next time. We've got Delegate Orrock.
Good afternoon, Mr. Chairman, members of the committee. House Bill 2648. And Mr. Chairman, members of the committee, under victim rights now, if the victim wishes to be notified when their assailant is being released from jail or prison, they have that right. What we have found out is a situation arose in my district where the assailant was adjudicated not competent and was then put in a mental facility. There was no means whereby the victim could know of their release. The bill as it stands before you as amended by House courts puts in place a mechanism whereby that victim would be notified by the Director of Department of Mental Health Rehabilitative Services. So it just puts them on parity that they would know their assailant was out in the community. The specific case that came to my attention, she found out when she saw him at the supermarket several months later and found out he lived 3 miles away from her now.
Do we have anybody here from the Department of Behavioral Health?
Mr. Chair, that's exactly what I was going to ask. I think this is a good idea, but I'm concerned about who is the best person to provide the notice.
That they were the ones, I would say, Mr. Chairman, and maybe my backup folks from from House courts, they were the ones that agreed to this language, that they would be the one that would be able to ascertain that information from whatever mental placement they had been put.
I don't know who ran this down, whether it was Crime Commission or Council, but I was given to understand that the Department of Behavioral Health already has a process pursuant to which it makes these notifications.
Then this was just put in place where upon request, because it not being in victims' rights.
Oh, I'm sorry, but I'm sorry, that's only for sexually violent predators.
Correct.
Okay.
This would
Gotcha.
expand it to any victim
Gotcha.
circumstance.
All right.
Mr.
Anybody have any?
Chairman?
Yes, Senator Howell.
It's not a question. The original bill was mine that did that in the first place. And I think this is a very important step forward for
Plagiarism is the
victims.
highest form of flattery, so.
No. I think
Anybody-
this is really an important bill.
Are you aware of any opposition to the bill?
No, sir.
All right. Anybody have any other questions of the patron? The bill is before us. It's been moved and seconded. The bill be reported. Thank you very much.
Thank you, Mr. Chairman, members of
Ayes
the committee.
15, noes 0.
Delegate Hodges.
Good afternoon, Mr. Chairman, members of the committee. I have before you House Bill 2484. If I may, Mr. Chairman, credit card crimes often occur in multiple localities, and the current law states that a prosecution may be had in any county or city where the crime actually and that credit card was used. So the result is that the crimes frequently must be prosecuted in multiple jurisdictions, which is a problem for the witnesses and actually the holder of the credit card. So this legislation simply adds language to the venue statutes, which would allow the cases to be prosecuted in the locality where the cardholder actually resides. It's a really simple bill.
Is this consistent with the venue provisions that we adopted in Delegate Cosgrove's forgery bill? Anybody know?
Mr. Chairman, in Delegate Cosgrove's forgery bill, it was the issuer, acquirer, or account holder, which the account holder is very similar to where a cardholder resides.
Okay. Maybe the Commonwealth's attorneys have some thoughts?
Mr. Chairman, Mike Doucette, Executive Director of the Virginia Association of Commonwealth's Attorneys. This is at a request of one of our members, and for the reasons that have been stated by Delegate Hodges, we support this particular bill. And this bill basically mirrors the language at venue on identity theft, which also has a provision that allows for it to be prosecuted in the jurisdiction where the victim resides. And so there is some other code sections that already do this.
All right. Anybody here in opposition to the bill? Anybody have any questions? Bill is before us. It's been moved enthusiastically and seconded that the bill be reported. Delegate Hodges, thank you very
Mr. Chairman,
much.
no 0.
Delegate Bell, you want to go? Or not?
I'm happy to, or I'm happy to wait.
Go ahead.
So, Mr. Chair, we have two bills, one of which is a analog to a bill that you have in terms of we're calling it the fingerprint bill on our side of the body. House
That is
Bill
the
2343.
2243.
And there are, in an effort to keep them in parallel, there were an amendment proposed by OES. I don't think it's substantive, but not controversial, and then a couple of technical amendments. Otherwise, I believe it's the same as your bill, although again, I'm not sure exactly where. And then I have a new matter for your consideration.
Having a hard time finding the bill. 2243. 2343.
So,
Got it.
Mr. Chair.
All right. Senator Stewart moves, Senator Stanley seconds the adoption of substitute. All in favor, signify by saying aye. All opposed. All right, Senator Delegate
Mr.
Bell.
Chair, if I might suggest the most constructive way to proceed would be for staff to tell you the differences from what you reported out. I think you'll find that they're not.
Okay. Charles?
Mr. Chairman, as
Or Colin? Whichever you prefer.
As Delegate Bell stated, most of these changes were very technical. And I can pull up the exact changes.
Colin, any substantive changes here?
Mr. Chairman, members of the committee, there's no substantive changes to the bill. The technical changes are captured in the amendments. There was an amendment made in Senate Finance to your bill to clean up some language regarding a show cause issued by the court versus a summons issued by law enforcement. That was technical in nature.
You aware of any opposition to the substitute? Anybody here in opposition to the substitute? All right, anybody have any questions of the patron? Is there a motion? All right, it's been moved and seconded the bill be reported. I think that was the easiest way to deal with it.
Thank you, Mr. Chair. There we go. Mr. Chair, my other matter, I don't believe had a Senate version. It was House Bill 2143. Mr. Chair, the members of the panel, the issue is airbags are being installed, and there's two issues. One is that some of them are counterfeit. They purport to be Company A and is not made by Company A. And the second is that they're non-functional. They have had airbags literally stuffed with sawdust, and of course they get installed. You don't know that they're not there to protect you until you need them, and then of course they do not inflate properly. There's also an issue about those who are installing these will install a device that the car actually has some safeguards against that. They install something that makes it seem as though it's a good airbag. It's not a good airbag. That's the sort of the third issue. There's some representatives from the industry who would be prepared to answer any questions or testify about the problem, and that's the bill.
All right, Steve, were there issues and concerns that we developed in work group about this?
Mr. Chairman, I think it was Colin who gets credit for picking up on this. If we criminalize the use of a counterfeit airbag, and in an accident, if the airbag is defective and is the source, is the cause of the injury, because of the policy in Virginia that a person is not responsible for the criminal actions of another, the concern that we had was whether this would create a defense for someone because of the criminal use of a counterfeit airbag. In other words, a superseding or intervening cause. A rough example is, if you sell too much alcohol to somebody and they're blind drunk and get into a car and drive and then kill somebody, even though you were responsible for getting them blind drunk, knowing they were going to get in their car, their act of driving the car while drunk was a criminal act. And so under Virginia law, we don't impose civil liability against the bartender. And we had a similar concern here. It would be obviously an unintended consequence. The bill seeks to do good, but it could be a consequence. And we haven't thought it out far beyond that, but wanted to raise that issue, that concern.
I don't want to do this on the fly, and I'm sorry for kind of blindsiding you. This kind of just came up, but Steve's and Colin, I think, are right, and the Supreme Court has written a great deal about that over the past couple of years. about civil liability for criminal acts of a third party.
Mr. Chair, if the committee's willing, we would ask that it go by for a little bit of time to see if there's something we
Why
can
don't we do that?
Mr. Chair.
And if you can look at it, we can even take it back for the
Mr.
And
Chairman.
Mr. Chairman, I have to apologize to Delegate Bell because now I'm recalling that I may have gotten a message from somebody asking me to take a look at this bill, and I never followed up. So it is my fault, and I apologize.
Mr. Chairman, one other issue.
Senator Edwards.
It occurs to me, this could be a product liability issue. I don't know whether the criminal penalty would affect that or not. It could be a product liability issue of
Well,
selling something that.
it
probably
would, to
won't
the
even.
extent that it is a products liability case brought on a negligence ground as opposed to a breach of warranty ground. So,
Mr. Chair, just so we don't come back 3 times and don't fix the issue addressed. So the second issue addressed would be the person that made the airbag were themselves malicious, and the purpose of the criminal charge would also track with being negligent. I think the original issue, though, would be that it somehow would let off the other driver. So somebody literally drives the wrong way in the road, hits head on.
yeah.
They would be getting off because 3 years ago somebody put in a bad airbag. Do I have it right?
Yeah.
Okay.
Yeah.
We'll get to work. Thank you, Mr. Chairman.
All right. Delegate Bell, is that
Yes,
it?
sir.
That all
Yeah,
we
the other
got?
one that you said was going to go by, I think.
Okay,
Yes,
that's
sir.
fine. Without objection, Senate Bill 2666 will go by for the day. All right, we've got Delegate Pogge.
Thank you, Mr. Chairman. House Bill 2253 actually will direct the Virginia State Police to, I lost my notes, to shorten the time that it takes to approve a non-resident concealed handgun permit. Right now, it takes about 6 months, 5 months to 6 months to get a non-resident CHP. We're asking them to do it within 90 days. Currently, with the modern technology that we have, multi-state background checks are available almost immediately for preschool teachers, daycare employees, emergency medical personnel, foster care, and adoptive parents, and many other areas where they're needed. Right now, the Virginia State Police says it takes 5 to 6 months to search their databases for a multi-state background check. And so what this bill does is directs them to do it within 90 days. In 2017, they received a federal grant to update their background check system, the V-check system. And the V-check system is used to process and approve the concealed weapons permits. And so it really shouldn't be taking 5 to 6 months. They should be able to do it in 90 days. There is a delayed effective date on this for October 1st to go into effect.
All right. Anybody have any questions of the patron? Anybody, and I'm going to have a couple of questions for you, but anybody wish to speak in favor of, in opposition to the bill?
Philip Van Cleve, VCDL. Yeah, we strongly support this bill. No other state even comes close to this long delay that we have. Other states handle much more out-of-state permits, and they get it done for less money and half the time or less. So this was a compromise. We originally were saying, why can't they do it at the same speed local government does? But that was an issue, so we doubled it to 90 days.
Okay.
Thank you.
Anybody else in support? How about in opposition?
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. We oppose this bill for a number of reasons. The first one being that it's very important that the state police, when they're looking at the person's background and they're not a Virginian, they don't necessarily have this information directly at their fingertips. And it takes time to get the information, to look at it. And if we put an arbitrary timeline on when they have to make a decision or they have to issue a permit to someone, it's quite possible we could be asking the state police to issue a permit to somebody who is not eligible to possess that permit. And I'd remind the committee that a couple of years ago, we now in Virginia accept permits from every other state. There is no longer a compelling reason for somebody to get a permit from another state, from Virginia, to be able to carry a concealed handgun in Virginia. Therefore, people are still doing it, but not for the reason that they have to. They're doing it because they want to circumvent the laws of their own state, or they want to circumvent the laws of other states by obtaining a permit which has more relevance and more reciprocity in
So
other
they may
states.
live in Maryland or New York or California that basically doesn't give concealed carry permits? And you don't want them coming to Virginia, or it gives very few concealed carry permits?
No, I think that right now, pretty much anybody can come to Virginia after that, the decision made 2 years ago, and everybody's permit will be recognized.
Okay.
What I'm concerned about is the fact that the Virginia State Police is a law enforcement operation, and I don't think we should be asking them to provide a piece of paper to somebody from another state that they can then use to circumvent the laws that their legislature put in place, or to circumvent the laws of another third-party state which didn't want to give reciprocity to that state.
Okay,
Mr.
thank
Chair,
you.
can I
Let's,
ask the chair, the sponsor a question?
yeah, I was gonna, sure, go right ahead.
Delegate Pogge, Mr. Van Cleve said that the 90 days was a compromise, and a compromise suggests there was an agreement of some kind. The state police, they've said they can get this done in 90 days?
I was gonna.
Actually, the original bill asked for 45 days, and so we amended it for 90 days, and hopefully that would be more reasonable to them.
Well, what I was asking, though, he said there was a compromise. That suggests there was an agreement. Did the state police say they could get it done in 90 days?
No.
Great. Why don't we ask the state police?
Okay.
Okay. This is not the gentleman I spoke to.
But this is the state police.
It looks like state police.
We spoke.
Step right up.
Mr. Chairman, Keenan Hook, Department of State Police. The department does not, the system, the VCheck system that Delegate Pogge indicated we are upgrading and automating is not yet in place. That's the reason for the delayed enactment. So we're not in a rhythm yet of seeing how quickly we can move with the automation piece. We don't know how much we will be able to shave off of our current 140-day turnaround time to get closer to 90 days. We do believe there will be some positive impact, but we also believe we're likely to need additional people to accomplish the 90-day goal. One important distinction to remember here is that unlike a typical background check that Delegate Pogge references that gets returned instantly, those are typically returned to the person making the determination, who may then take an extra period of days or weeks or months to decide whether the background is suitable. In our case, we have to do all of that on the front end. So that's why it's not a good analog to compare to a private background check.
Well, then, Mr. Chair,
Senator Deeds.
well, have you figured out in your analysis how many additional positions it would take to meet the 90-day? I mean, it seems to me probably that's a difficult question, but I mean, I assume that those new positions are in the House version of the budget. Is that correct?
And I'll tell you that there is a fiscal impact that says no money is required, I don't believe.
Mr. Chairman, I believe it was indeterminate, if I recall correctly.
Officer Keenum just said that
I know he's.
additional
I know.
positions would probably
That's
be
not
required.
what the submission said.
Mr. Chairman? Mr. Chairman?
Does it say that there are multiple additional positions?
Mr. Chairman, I believe when DPB looked at it, and I don't have it in front of me, but my recollection is when they looked at what we submitted, they concluded that there would be an indeterminate impact. Now, I look at a lot of these. It's possible if you've got it in front of you, I'm
No,
misstating.
you're right. You're right about indeterminate impact. I just don't see anything about additional positions being required.
That would be the impact for us at this point. The VCheck system is paid for out of grant. The only additional thing we would have is.
So is it that your upgrade is going to allow you to comply with the 90 days, but you're just not sure how long it's going to take to implement your upgrade?
No, Mr. Chairman. Our upgrade simply will automate part of the process that deals with getting the applications in, initial processing. But at some point, people have to touch these criminal records and review them all and research potential disqualifying convictions and things to see that they are, in fact, disqualifying. None of that can be automated. And we're still dealing with a staff here. You go back a decade, we were getting 500, 1,000 permits in a year. We've, at the same staffing levels, last year, we got 13,000 in, so.
Mr. Chairman?
All right.
Mr. Chairman?
Sarah Stewart, Sarah Peak, and then Senator Reeves.
Thank you, Mr. Chairman. Either Delegate Hoagie or Keenan, I understand what you're trying to do and supportive of it, Delegate, but I have one concern because I'm more worried about our residents than out-of-state residents. So is there any way that expediting out-of-state permits could cause a delay in in-state permits? Or background checks for, if I want to buy a new shotgun to hunt dove, is that going to affect that? I want to be sure of that before I pass on this.
Mr. Chairman, no. The one would not affect the other, Senator Stewart. The non-resident background checks are processed by one staff. Of course, resident permits are handled by the circuit courts. All we do is enter them in VSIN. That process is now automated, so it wouldn't impact that, and it wouldn't impact other background checks, which are done within other sections of our CJIS division.
Sarah Peak.
Thank you.
Yeah, would constitutional carry cure all these problems?
Are you asking me?
Or from state police? You wouldn't have to do any checks then, would you?
Mr. Chairman, it would presumably eliminate the need for a non-resident permit.
All right, Senator Reeves,
So-
and then we're going to move
Okay.
forward with the policy issue.
I'm just trying to understand, from the state police, when did V-Check go into effect?
Mr. Chairman, Senator Reeves, V-Check has been around for a period of years to process purchase transaction background checks. We're now using that same framework to add the non-resident permit background checks to it. So that new enhancement will be in effect. The grant expires in October. I don't believe we'll actually be finished quite by October, but we'll be on the heels of that.
Mr. Chairman, further questions?
Senator Reeves.
So does V-Check include VSIN and NCIC checks as well?
Mr. Chairman, Senator Reeves, V-Check is the system that that automates the query to NICS and VSIN. So NICS does the NCIC check for us. That's the National Instant Criminal Background Check for federal firearms purchases, and the VSIN check, and mental health also within Virginia.
Last question, I promise, Mr. Chairman.
Senator Reeves.
So if I'm on the street and I run a 1028 or 29, how fast can I get that check back?
Mr. Chairman, Senator Reeves, instantly usually.
So is there?
Last question.
That's my question, Mr. Chairman.
Senator Stewart.
May I make a comment? I'd like to mention two things. I kind of,
I think there was a motion to report it. That would be a good thing.
okay, is that what you're going to do?
All right, there's a motion properly seconded that the bill be reported. The roll is open.
Ayes 9, no 6.
Thank you,
The
committee.
bill reports. Thank you. Next, we have Delegate Hurst. I'll remind for those late-coming delegates, we'd be happy to call you all. The lineup is Hurst, Sullivan, Campbell, Mullen, Tyler, Jay Campbell. So that's the order, and if I didn't call your name, you're farther down in the queue. So we'd be happy to call you. Delegate Hurst.
Thank you, Mr. Chairman, members of the committee. Before you is House Bill 1720, which should be familiar to you, at least in its intent, to Senate Bill 1632 that was patroned by Senator Sturtevant that passed out of the Senate. It's similar. I had actually introduced a substitute in House courts for a full committee, and that was amended. That substitute was to conform with Senator Sturtevant's bill. It was then amended to take out some of the provisions in it. If it pleases this committee, I have no problem conforming that bill back to Senator Sturtevant's bill, and then maybe we can hash it out in conference.
You know, so Kristen, any idea why we have this instead of Ed and Health? And I know you've been sitting here, and I apologize for that. But these bills have been, this session, been handled by Ed and Health Committee, and should have had this up at the top of the docket. So I think what we are going to do is re-refer this bill. I hate to do it because they've got a crushing docket. You want us to deal with it?
Mr. Chairman,
We did,
Mr. Chairman,
Senator Sturban.
to the extent it matters, I think as Delegate Hurst pointed out, I had a bill that passed unanimously, I think through committee and the Senate, and I think he's offering to conform it to that one.
Yeah, why don't we do that?
Form.
All right. That's a good suggestion. All right, the motion has been made, properly seconded, to conform Delegate Hurst's bill to Senator Sturdivant's bill.
Which, Mr. Chairman, just for reference, is Senate Bill 1632.
1632. Okay, the motion's been made, properly seconded. Anybody here in the audience wish to speak in opposition to that? All right, roll is open. All right,
Thank you, Mr.
Delegate.
Chairman, members of the committee.
Delegate
We
Sullivan.
got a report now, it's conformed though.
Conform and report.
Yeah.
You got that, Hobie? Okay.
Conform.
Delegate Sullivan.
Good afternoon, Mr. Chairman, members of the committee. This is HB 2242, which is brought at the request of the Boyd Graves Conference. It affects statutes of limitations, or relates to the section 8.01-246 relating to statutes of limitations in contractual cases. It stems from a, frankly, rather obscure opinion of the Virginia Supreme Court of just a couple of years ago. It's called Donovan v. Bagwell, which dealt with the distinction between a written and an unwritten contract. Every lawyer, it's first thing you learn in contract law, at least with respect to Virginia, written contract 5 years, oral contract 3 years. What's often left out, of course, is that what 246 actually says is it's a written contract signed by the party to be charged. And what happened in Donovan v. Bagwell is that the court reminded, relying on another case named Dixon v. Hassel and Folks, reminded that there can be written contracts that are reduced to writing, not signed by the party to be charged. But the parties can, between themselves, consider it an enforceable contract. So in the context of when a contract's enforceable, it can be written. What this case did is it went out on the issue of whether the 5-year statute of limitations applied.
Was it an insurance policy?
It was a legal malpractice case.
Okay.
But what happened was the court dropped this sort of ominous footnote. And it said, look, this doesn't go out under the 5-year, but we don't have to decide whether it goes out on the 3-year unwritten, Part 4 of 246, or whether it goes out under the catch-all 2 years because it's out under the because it's out anyway. So what the bill does is make very clear that in a situation where you've got a writing not signed by the party to be charged or an oral contract, it's 3 years. What we want to avoid is the possibility that you could have a writing not signed by the party to be charged could arguably does under the court's case have a shorter statute of limitations than an unwritten oral contract, a 2-year statute of limitations. So this simply makes that clear for any unwary lawyers.
Delegate, you aware of any opposition to the bill?
I am not.
All right. Anybody have any questions of the patron?
I move the report. It
All right.
fills
It's
the
been
gap.
moved and seconded. The bill be reported. Roll is open.
It's kind of unusual.
Ben?
Thank you, Mr. Chairman. Members of the committee.
All right. Thank you very much. Next, Delegate Ronnie Campbell. Welcome, Delegate.
Thank you, Mr. Chairman.
2439.
That one will work. 2439 is a technical amendment to the DNA databank collection requirements. This bill was unanimously endorsed by the Crime Commission as a technical amendment following last year's study on the expansion of misdemeanor crimes in the DNA databank. This is a cleanup bill to require that DNA sample submitted for any conviction under local ordinance that is similar to the misdemeanors in the existing. The bill conforms the DNA sample submission statute to fingerprinting statute. The fingerprinting statute 19.2-390 requires that fingerprints be obtained for offenses under Title 18.2 or 19.2, or for offenses under similar local ordinances. This bill will provide clarity to law enforcement, courts, and the Department of Forensic Science on when a DNA sample is required and when that sample can be included in the DNA database.
So this has some technical differences from Senator Chafin's bill. And I understand this does not put it in conflict. Is it the intention of Crime Commission to conform this with Senator Chafin's bill or not? You have a preference, Delegate?
They gave it to me.
Mr. Chairman, I believe the difference between this and the portion of Senator Chafin's bill was just an of. I think there were other parts of Senator Chafin's bill, but the language between the two is essentially the same. It's just a difference of an of, and I don't think that makes a big difference.
Okay. Do you have a preference, Kristen, whether we keep the of or not?
Well, there are a couple of other commas and ors and ofs and things like that. They are technical in nature, and because the bills otherwise aren't identical, because Senator Chafin's bill has additional parts, the bills would not be in conflict, and whether there's an or an of or a comma here or there, it will just be whichever is signed last by the governor would go into law. But neither one
Okay.
of them is technically different.
All right, Delegate Campbell's bill is before us. Is there a motion? You want to conform it? All right. Doesn't undermine the Crime Commission's efforts, does it?
Yeah,
Okay.
I'm comfortable with.
Motion is to conform and report. Properly seconded. Roll is open.
Ayes 15, no zero.
All right. You have another bill?
Yes,
One more.
Mr. Chairman, 2769.
I think, can we already deal with that, Kristen? Yes, sir. All right, we already reported that one out. You're good.
Thank you.
Delegate Mullen.
Good afternoon, Mr. Chair. How are you?
Doing great.
I have two bills.
1673.
Yes, sir. So 1673, all bills have a story, and this one is related to the hurricane scare that we had down in Hampton Roads this past year. A couple of judge friends of mine pulled me aside and noted the fact that, at least technically, preliminary protective orders that were due on the days in which the courts were closed expired. And so we have worked now, I believe there's an amendment in the nature of the substitute, is that right? To use, I think, some better language that has been suggested by court system. And so all this would do is essentially say that if the courts have to be closed because of an emergency, that the preliminary protective orders will continue until such time as they can have an actual hearing.
All right. And Delegate Supreme Court here. Good afternoon.
Good afternoon.
You have any thoughts about this good bill?
The patron was very kind in working with us on it, and we have
No logistical issues?
No.
Okay.
although I suppose I should look at the substitute before I.
The substitute, are those technical, largely technical changes?
Yes, they are largely technical changes. And when we spoke earlier.
Yeah, these are the changes we discussed. We're fine with this.
Okay. All right. Anybody have any questions of Patron? Anybody here in opposition to the bill? Bill is before us. I'm sorry, did we adopt the substitute? All right, let's strike the roll. Senator Stewart moves, Senator McDougal seconds. We adopt the substitute. All in favor signify by saying aye. Aye. All opposed. Substitutes before us. Senator Stewart moves, Senator McDougal seconds. That we report the substitute. Roll is open.
Ayes 14, no zero.
Hal. All right. Bill reports. Next, you have 1771.
Yes, Mr. Chair. So this is a recommendation of Speaker Cox's School Safety Committee that we spent the last year working quite hard at, including up your way, Mr. Chair, this past summer. What this does is it opens up a third avenue of being able to access early help for those children who are in crisis. Right now, the only time that we can give services to students who are in need is if, one, there is a child in needs of services petition, a CHINS petition, that has been filed, or that they have been found delinquent in a criminal offense. What this does is it allows for a third option that does not involve immediately entering into the criminal justice system, so that we can get psychiatric services, wraparound services, in-home services. And so this bill would allow for school counselors and those in the schools to actually do the same sort of DJJ style evaluations to be able to access those services and, in hope, save the Commonwealth some money by getting to these kids before they end up in my former courtroom as a prosecutor.
Are you aware of any opposition to the bill?
No, I am not.
Okay.
But sometimes we can
DJJ, good with the bill?
They took no position.
Okay. Anybody in the room wish to speak to the bill? Anybody have any questions of the patron? The bill is before us. It's been moved and seconded. The bill be reported. Roll is open.
Ayes 15, no zero.
All right, that bill reports.
Thank you,
very
Mr.
much.
Chair. It's always a pleasure to see you.
Good to see you. Next, we have Delia Tyler.
Thank you, Mr. Chair and members of the committee.
1833?
Yes, 1833. This bill was presented at the request of the Virginia Parole Board. And basically, this bill will allow the parole board to make the pre-sentence investigation report available for review without a court order for incarcerated persons who are eligible for release by the Virginia Parole Board of such personal counsel. Under current law, the parole board does not have legal authority to allow parole-eligible offenders to access their pre-sentence investigation report. And to speak to the bill, I do have a representative from the parole board.
All right, we'd be happy to hear from him.
Yes, sir. Good afternoon, Chairman. Adrienne Bennett, Chairwoman of the Virginia Parole Board. Also here today is Professor Bruck from Washington and Lee University. And this bill was brought or requested, really it was inspired by the law students at Washington and Lee. They have started a parole clinic, and they have frequently requested to be able to look at the pre-sentence investigation reports and determining who they wish to represent and how they wish to represent that individual. And we have quickly learned that we lack the authority to do that as set forth in the current statute without the amendment. We'd like to be able to cooperate with them. We think it's a matter of fairness and transparency for other offenders as well. So we would ask that this committee pass this bill. So.
Okay, let's hear from the professor, and then I think the Commonwealth's attorneys would like to be heard.
I don't have much to add to that. It's the courts can already provide and are supposed to provide on motion a copy of the PSI report to any counsel for the prisoner, but it requires a court order. If in habeas cases it does not require a court order, there's no logical reason why it wouldn't apply in parole cases where the PSI is particularly germane. So it seems it's just a technical fix to reduce the paperwork and the trouble and expense of getting the PSI to counsel and to the offender at least to be able to review it under parole board regulations.
Okay. Thank you very much. Yes, sir.
Thank you.
Mr. Chairman, members of the committee, Darrell Puckett, Commonwealth's Attorney for Appomattox County for the Virginia Association of Commonwealth's Attorneys. I would just like to echo what the professor and the representative of the Virginia Parole Board have stated to the committee today. The association supports this bill. By doing this, it would further streamline the process where we wouldn't have to secure a circuit court order to get that information over to the parole board. It adds more transparency.
Okay. Any member of the committee have any questions? Anybody else wish to be heard on the bill? Bill is before
I
us.
just have a question, procedural matter. It's counsel for the defendant gets a copy of it. So, and that means the defendant has a copy of it. You're talking about the pre-sentence investigation report, right? Is that what we're talking about? And why wouldn't they already have it?
Yes, sir. Many of these cases are 30 years old,
Okay.
and so oftentimes the offenders don't continue to have a copy of their pre-sentence
Yeah.
investigation reports.
So it just continues.
Sir Edwards.
Mr. Chairman, it just continues the existing policies, just, they don't have it anymore, that's all, okay.
Correct, but we don't have the authority to provide it to them if they've misplaced it. And it's caused a lot of issues with, I think, for some Commonwealth attorneys who've been asked to sign off on consent orders allowing for the attorney to obtain a copy. So it's just really streamlining the process. And it is something that the offender should have already seen at the time of sentencing, one would hope at least.
All right. Motion's been made to report the bill. Roll is open.
Ayes 15, no zero.
Thank you.
Thank you.
All right, thank you. Next, we have Delegate Jeff Campbell. And just for your benefit of those waiting, next is Delaney, Ferris, Richard Bell, Carr, and Cole. All right, Delegate Campbell.
Good afternoon, Mr. Chairman. House Bill 1944. Your committee has seen at least a version of this bill before, I think, and passed something in that regard.
Now, yeah, this bill is similar to Senator Servell's bill, 1542, which reported out 13-1 and out of the Senate 39-1. And my understanding is that this is a bill that comes to us from the Poverty Law Center. You've worked with them, and maybe they prefer your version of this bill. And so as a consequence, I'd like to hear from you and maybe the Poverty Law Center. I think Senator McDougall may want to listen up because I think the amendments that we made were amendments that he had some interest in. Am I correct? Okay. Tell us why you don't like what we did.
Thank you, Mr. Chairman, members of the committee. Valerie LaRue from the Virginia Poverty Law Center. And I think the concern that Senator McDougall had drove the amendment that this committee made to Senator Servell's bill. But the problem is that in doing so, it basically set the law exactly the way it is currently, except it added a special burden to divorce litigants. What the House Courts Committee did with Delegate Campbell's bill was take the same concern, but make the wording slightly different so that it doesn't add that burden, but still provides for that sort of backstop that I think Senator McDougall was looking to.
Tell us, refresh our recollection for those of us who don't practice in this area. What was the burden before these bills? And what did we add, and what are you trying to take away in Delegate Campbell's bill?
So the current law, which was passed by the General Assembly in 2017, basically pulls all the factors from the criminal statute where a defendant is seeking, an indigent defendant is seeking appointment of counsel. And so it just basically says to make a determination about whether someone qualifies for the waiver of fees, look here. And so what the original bill did, and the problem with that is that it's being applied inconsistently and differently in different courts. So what the original bill did was basically take this similar language and factors, put it into this statute, but in doing so, clarifying and getting rid of some of the things that was making, or hopefully getting rid of some of the things that was making the application different in different courts.
If you're receiving
public benefits. And then it added something which was the legal aid presumption. But there's already a presumption for receiving public benefits. The court committee, I guess, didn't want to go quite that far as the original bill, but understood that because of a constitutional issue having to do with a case that came out of the Supreme Court, that divorce litigants sort of have a special situation where they cannot settle out of court. They can decide out of court that they are going to agree to a divorce, but they can't get a divorce by agreement. They have to go to the court. And so you can't foreclose people from getting a divorce by creating a hurdle, which is the fee if they can't afford it.
The difference is that Delegate Campbell's bill says if you're getting public benefits, you can't be charged the fee. What we did in the bill that went through the Senate was said, if you're getting public benefits, there's a presumption that you're not charged the fee.
Which already exists.
So what you want to do is go back to no fee if you're getting public benefits, but the recipient has to certify that they're receiving the public benefits, right?
Correct, although it wouldn't be quite correct to say going back because that doesn't exist currently, but yes, exactly.
Right.
No report.
So if you became, Mr. Chairman, if you became eligible to receive benefits, how long ago did that eligibility have to exist before we create this exclusion? So when was that eligibility determination made?
So generally, eligibility for public benefits is something that is ongoing, that people, and I don't know what the periods are, it might be monthly, whenever they get whatever their benefit is, that they have to ascertain that the person's situation is still the same. And so what Delegate Campbell's, the House Court's version of Delegate Campbell's bill would make the person have to certify that, yes, they are getting them now. So it would be a present certification.
Mr. Chairman?
So does Medicaid qualify?
Yes, I think the original.
For some people, Medicaid is at a certain income level. Some people, depending upon pregnancy or some factors, maybe 300 times poverty level?
300 or 400.
400 times, or 400% of the.
Well, a person who's pregnant can't get an uncontested divorce.
400%.
A person who's pregnant can't get an uncontested divorce.
Okay.
Yes, the court sort of is 120% of poverty level. That's the poverty level that they're supposed to be looking at. Most benefits are in the range of 120 to 138%, I think, of poverty.
So it's any public benefit at all?
No, not any public benefit at all, but any public benefit that's meant to assist the indigent or the poor.
Federally funded public assistance program for the indigent. Okay.
Correct.
Senator McDougal.
So is the Medicaid expansion, we went above 120% of poverty level, correct?
Well, this language is exactly the same as what's in the criminal statute right now for someone getting an appointment of counsel. The difference is that for appointment of counsel, you're getting at the bottom $120 benefit because that is the minimum amount that someone gets for representation.
Mr. Chairman, but
yes.
if we tie it to, on the court-appointed statute, the court goes through and asks about your specific assets, your ability to pay, your income.
Exactly.
We're saying this time that, though, that if you get Medicaid, that's made through a different determination, that you can be greater than 120% of the poverty level, where you can't consider any other factor than the fact that you get it.
And the reason for that is because when you're getting appointed an attorney, the least amount of that value is $120. That's for a misdemeanor representation. For filing a divorce in court, it's $42. So the amount of the benefit you're getting is very small. It's $42. To do that inquiry that you're talking about requires both the court clerk and the judge to do a lot of work to determine somebody's assets. So is that worth $42, especially when you're just talking about uncontested divorces, which basically are not hearings. They're just paper that's put before the court. The court looks at the paperwork and then makes a decision about whether all the pieces are there and then signs off on the decree. So there's no court time really taken up with it. There's probably more court time taken up with digging into someone's finances in those small situations.
Okay. Senator McDougal.
Mr. Chairman, I move that we conform House Bill 1944 to Senate Bill, the language of Senate Bill 1542.
Is there a second? All right, there's a motion properly seconded, the bill be conformed and reported. Delegate, if we do that, I assume you'll conform the Senate bill, and we will meet and work out our
Work out the
differences
details. That's the
and
plan.
continue this conversation in a different setting. Motion has been made to conform and report. The roll is open. Somebody has center peaks. Oh. All right.
Ayes 13, no zero.
That reports. You have another?
I do, Mr. Chairman. House Bill 1945 is a bill that you have already seen and passed as well. And I think the Senate version of this is identical to what the House passed.
We already take that up,
No,
Kristen?
Mr. Chairman, there is one difference. The House Courts Committee added language on lines 23 to 24 saying that in the final decree of divorce as proposed by the complainant is signed by the defendant.
Okay, we did.
I do too.
We fixed something correctly for a change.
Poverty Law Center likes your version again
Mr.
better?
Chairman, we like the House version once, we don't like it once.
They don't like it better.
We don't have an opinion. We like them either, so. this is-
Okay.
Move to report as it is.
All right. Is this the Family Law Coalition standing behind you?
Actually,
These two bills were intended to try to make the process more efficient and streamlined. So on this issue, that the issues that were raised in House courts were the fact that they wanted to give the defendant a little more protection, so they added the "and." The second issue is just a clarifying language change, because the language actually read that you would have the defendant sign the final decree. Judges grant final decrees, and so it was really sign a draft of the proposed final decree. And that's fixed, and I think this adds a little protection. We're happy with it. Virginia Bar's happy with it. I think the court is happy with it.
All right.
I think everybody's happy with it.
Kumbaya. Motion has been made to report. Roll is open. All right.
Ayes 13, no zero.
That bill is reported. 1954.
Mr. Chairman, House Bill 1954 provides for an amendment to the Virginia Uniform Power of Attorney Act to allow for the awardance of attorney's fees and costs to a party in a judicial proceeding under the act. I think currently the problem is that there's no provision for the award of such, and as a result, a lot of attorneys are hesitant to get involved in that type of litigation, even when it's clear that a fiduciary may be breaching their obligations under the act.
So this is a fee shifting clause that allows the fees to be shifted either way, right? Jeff?
Mr. Chairman, members of the committee, Jeff Palmer on behalf of the Virginia Bar Association. This is a recommendation of the Wills Trust and Estates section, and we did work with the Virginia Trial Lawyers Association on the legislation that's before you. There's a separate statute, 64.2-1615, dealing with liability of the agent that says that the agent is liable to the principal for certain acts. But in a recent case this past year of Mangrum versus Chavis, attorney's fees were not permitted because it was the beneficiary that was bringing the suit, not the principal herself. And so we have, this mirrors a similar provision that's in the Uniform Trust Code that is actually much broader than what we're talking about here.
Mr. Chair.
Yes.
Sarah Peterson.
You awoke me from my slumber with the word attorney's fees. Is under breach of fiduciary duty under common law, you can recover attorney's fees for breach of fiduciary duty and fraud. if you get a finding?
Well, so under the case this past year, the Supreme Court found that the fees were not permitted in that case because the party bringing the suit was a beneficiary to the principal, not the principal herself. And so the existing code section, section 1615, did not, said that it's only the principal's attorney's fees that could recover.
Well, hang on. So there are provisions in which a third party can bring a breach of fiduciary duty claim seeking an accounting, for example, alleging breach of fiduciary duty. Is this going to apply to that? So if I'm representing children of a decedent and sue the attorney-in-fact, claiming that the attorney-in-fact misappropriated funds or simply ask for an accounting, alleged breach of fiduciary duty, can the children be charged with attorney's fees under this for seeking that accounting or making a claim of breach of fiduciary duty against their father or their mother's attorney-in-fact? I don't mean to do any harm, but I worry about fee-shifting provisions that are going to deter people with legitimate claims from bringing them. That's the whole reason we don't have a loser pays system in America, is people with legitimate claims are not going to bring them if they are afraid that it's going to be ruinous to them if a big law firm defends and they're going to get stuck with $100,000 of fees and lose their house for simply asking for an accounting or for mom's money back.
Well, Mr. Chairman, members of the committee, I think the concern originally was that the exact opposite would happen, that you'd be concerned about bringing the case because you'd be spending down the agent's assets or the principal's assets to recover for a breach of fiduciary duty. But if the committee's wish is to narrow it, we're happy to have that conversation. I think the Mangrum versus Chavis issue was the beneficiary of the principal. I'm sorry, excuse me.
And Mr. Chair.
Sir Deeds.
And that would be like if I granted a power of attorney to Peterson and then was struck by a car and in a coma, my wife or daughters would not be entitled to attorney's fees under common law if they filed suit on my behalf, but they would under this bill.
Correct.
Yeah, that's.
Mr. Chairman,
Edwards.
the rule is in Virginia, as I understand it, unless there's a statute authorizing it or an agreement, like a note or something, you don't get attorney's fees, except in civil rights in certain unusual cases. Why is it an attorney's fees be awarded in the case of somebody suing the agent under power of attorney?
I tell you what, why don't we take this by for the day, let you all go back and look at that and make sure that this is not overbroad, okay? Let's do that rather than take other patrons' time. Okay, without objection, this is going by for the day. Delegate Delaney. I'm sorry, you have another.
I have one more.
1955?
1955, Mr. Chairman, members of the committee, this bill, I think, is a recommendation of the Boyd's-Graves Conference. It simply provides that on appeal, damages would only be awarded on the part of the judgment that was actually affirmed.
Delegate, you aware of any opposition to this?
No.
This, anybody here to speak in opposition to this? This did come out of Boyd-Graves Conference. Senator Reeves moves that the bill be supported. Is there?
We don't know.
They're both ends of the bar.
Mr. Chair?
Senator Peterson.
And I'll ask Delegate Campbell this. why wouldn't damages always be awarded? If I get a judgment for 100 grand on a PI case, it goes up on appeal, and the appeal is denied, of course I get the damages.
Jeff?
I don't understand what this is doing.
Mr. Chairman, the current statute on the award of damages is vague and could be interpreted either way, either in full only or when it's in part. So it's up to the current clerk of the Supreme Court to determine when damages are awarded, and the current clerk has interpreted this and used her discretion to only award damages when the judgment has been affirmed in its entirety, and when the judgment is affirmed in part, there are no damages
Well, hold on a second.
awarded.
Depends.
Hold on. I had a case which was a fairly large appeal that went up where they had a judgment for 13.8 million and it got reduced to 5. And there was 5 bonded out and they took the letter of credit. So I'm not quite sure. And that was a Supreme Court appeal. This Supreme Court or Court of Appeals?
Supreme Court.
Okay, so I'm not quite sure I understand. I
really.
mean, I don't have a problem with the bill. It's just,
Sure.
I'm not quite
Well,
sure.
the Boyd Grave Conference felt that it would be helpful to bring some clarity to the statute, and
When is this guy Boyd Graves going to run for the House of
Yeah.
Delegates?
one of these days.
Money Boyd ran for Attorney General,
I'm
as a
pretty
matter of fact.
confident that an invitation can be arranged for you to attend the conference and participate in the
A
deliberations.
thrilling 2 days of your life.
Mr.
Mr.
Chairman, I don't get this bill. That's exactly what the law is now. If somebody misinterpreted it, that's
Jeff, what
their
chapter
problem.
is, I mean, is this in,
This is in 8.01, 682.
what's the chapter?
Oh,
This is what news should be about.
I don't know off the top of my head,
Where the hell is
Mr. Chairman. But the,
This is news.
Engaged, we need to know about
when the judgment is only affirmed in part, there's an open question about whether damages are awarded.
Pardon my gosh, man, that's news. Sorry.
That's real news, not this stuff that they're doing over here.
That's what I want to know. Why was she just wearing one glove?
I mean,
Might be an accident. Like,
This is,
Mr. Chairman, the Supreme Court can bring some
Yeah,
light to
thanks.
this.
I'm sorry, I might be able to clarify in a way that's helpful.
I understood this at one point.
Well, y'all are using damages in two
I
different
know,
ways.
that's what I thought.
You're talking about your verdict. What this has to do with is the damages that the appellate court awards to the prevailing party on appeal,
It's called
which is a
cost.
matter of a few $100s.
that's,
Right.
that's cost. That's not damages.
Yeah, that's not
That's
damages.
cost.
That's cost.
That's cost. Two different things.
This is the statute that addresses it, and if you look on line 11, 12, it uses the word damages in the existing statute.
Well, you know
It
what?
does.
That's not what it's costs. There's a big difference.
I don't know who wrote that code section, but that was not.
I'll ask the Boyd Graves Conference to go back
Can you,
and
can we
rewrite
put this
that.
off for a week and go back and
The-
rethink this?
I mean, the title of in the code is what damages are awarded.
Yes, sir.
All he's doing is dealing with the code language as it exists.
And the maximum is $2,500.
Yeah.
Maybe we really need to redo that code section, change damages to cost.
You know, after your Housing Commission bill, or is the recodification bill, I think that Counsel, Ms. Walsh, has volunteered to help you rewrite
My letter of resignation
8.01
will be
of
on
the
your
Code
desk
of
in the morning,
Virginia.
Mr. Chairman.
I think she just quit. Is the,
I see the confusion
I-
now, though. I wondered,
Yeah, and when I first looked at this, I totally forgotten that, but I had to go back and pull the code as well. But it makes sense to me.
Yeah.
Is there a motion? It's been moved and seconded that the bill be reported. The roll is open.
Actually, I'm going to go no anyway. I'm with you, John.
thank you, Mr. Chairman.
Ayes 12, noes 2.
All right, Delegate Ferris is about brewing, oh, he's gone. He's brewing over with excitement. No, sit down, don't get up. Delegate Delaney is next.
Good move.
All
Delegate Delaney.
Thank you, Mr. Chairman and members of the committee. HB 1820 helps address a very serious sexual predator loophole with a pretty straightforward approach. The bill before you prohibits employers from requiring an employee to sign a non-disclosure agreement or a confidentiality agreement at the time of employment or contract renewal for the purpose of concealing details of a claim of sexual assault.
So, we did deal with a statutory provision earlier in session dealing with public policy considerations that would have prohibited a settlement agreement from containing provisions that prohibit somebody from contacting law enforcement or making a complaint to an appropriate regulatory agency in settlement of a claim of discrimination or wrongful termination under certain statutory provisions. Maybe it was Senate or House bill, I can't recall. Maybe not. But is this like a prospective approach saying if I am sexually assaulted during the time of my employment, I agree that I will never speak of that?
So, Mr. Chairman, unfortunately, when an employee signs a non-disclosure agreement or a confidentiality agreement, we've seen some stories play out in the media of high-profile employees that have signed an NDA or a confidentiality agreement, and as a result of that NDA or confidentiality agreement, it's being used to silence them. And so what we're simply trying to say is that if you're signing that agreement up front, that it cannot be used to silence those kinds of claims. It can still, you can keep your trade secrets, need to remain confidential. All the other aspects of an NDA or a confidentiality agreement will continue, to be permissible. But it simply states that if the NDA or the confidentiality agreement has the purpose or effect of attempting to conceal the details of a sexual assault, then that would be against public policy and is unenforceable. So it's catching it at the front end.
Okay, and I don't think got any problem with it. I just want to understand
Yes.
what it is that you're getting at. I mean, Steve, I don't know whether you have any thoughts as to whether that would be void as against public policy as is.
I don't know the answer.
Kristen?
Mr.
This year?
Chairman, there was a bill, Senator Howe's Bill 1423, that, as you stated, dealt with disclosing information to law enforcement officers, and it was the determination of the committee that that was already the law, that you couldn't prohibit somebody from talking to law enforcement.
But this is broader than that.
Yes, Mr.
Correct.
Chairman, and we did work, I know the Attorney General's office did come by the office to talk about this bill, and we did work with the Employment Division of the Virginia Bar to resolve any concerns in the House Committee. So we are,
So, well, let me ask you this, and in a situation in which I'm never worried about the guilty person. I mean, if somebody, and we deal with these, horrible bills every couple of years dealing with child predators and statutes of limitations, and so far as I'm concerned, you can throw them under the jail, but if they did it. But want to make sure that there's due process for people who didn't do it. And every once in a while, there is a situation where there clearly are situations where claims are made and people settle these cases where they did it. And there are claims, and I guess this would cover a settlement agreement too, wouldn't it?
so, Mr. Chairman, this really just catches it up front. Settlement agreement, arbitration agreements would be a separate matter, and that would still be something that all parties could discuss.
Employee to, as a condition of employment. As a condition of employment. Okay.
So we're catching it up front, Mr. Chairman, and if I
Right.
could also add to your other statement, regarding law enforcement and being able to approach law enforcement, one of the reasons why this has been identified by a lot of victim advocacy groups as a loophole for sexual predators is that when someone is assaulted in the workplace, they don't have the mechanism to warn those who come after them. So it might be one matter where it might be quietly handled. You have the provision to quietly handle this in law enforcement, but if you're not in a position where you're allowed to tell others about what's happened, then you're.
Mr. Chairman?
Senator McDougal.
Am I, and maybe Mr. Benjamin or Charles can help me on this, am I reading the summary that's with this bill doesn't have anything to do with what the bill looks like currently, as far as the actual language?
I don't read the summaries. Charles is looking.
Mr. Chairman.
Mr. Chairman, the summary is correct.
Mr. Chairman.
Well, Mr. Chairman, I got a question. Give me a real-world
Chairman.
example of this. I talked earlier with the Attorney General's office regarding you cannot prohibit somebody from contacting law enforcement.
He jump you.
But this, give me an example of how somebody would say, the employer would say, I'll keep you on the job if you keep your mouth shut. It doesn't make any sense.
So, Mr. Chairman, Senator, I think a real-world example would be if someone signs an NDA or an confidential agreement in employment, they're sexually assaulted, perhaps by a supervisor, they leave their place of employment or they stay, but that original non-disclosure agreement is preventing them from maybe telling a colleague, watch out, because this happened to me, maybe preventing them from going public with a story aside from law enforcement. And so it allows that perpetrator to have essentially guaranteed the silence of people in the office and that might be in the same place of employment from being able to share their story publicly, allowing them to continue to offend.
So you have somebody who was assaulted and they settle for money. And you cannot say that this non-disclosure agreement is a condition of your working. So you're basically saying, I'm settling, but there's just no non-disclosure agreement, period.
So, Mr. Chairman, Senator, if a settlement is chosen, then there could be a later mutually agreed upon non-disclosure agreement as part of a settlement or an arbitration agreement. That would still be allowed. This is simply preventing upfront signage of an NDA or a non-disclosure that would prohibit disclosing. If both parties are agreeable to say, I'd like to handle this quietly, I'd like to sign an NDA and reach a settlement or an arbitration, that is still available to both parties. This is just preventing the upfront.
Mr. Chairman, well, up front would be like, you can come
Senator-
to work, but if this happens, you can't tell anybody. I've never seen that actually occur. I've represented people involving
I think
sexual
it's a-
harassment against some major
I don't think it
employers.
does any harm.
But I don't see how it works. I don't understand it.
Senator Howell?
Mr. Chairman, as you all know, I'm not a lawyer, but this just makes common sense to me. You can't, as a condition of employment, say you can never come forward with something that might happen to you in the workforce. I mean, I don't see how anybody could defend that position. If something happens later and then there is a non-disclosure agreement as a result of that, that's a different situation. But I think what Delegate Delaney is saying is you can't make it a condition of employment that you will never accuse anybody of a sexual or other kinds of harassment.
Well, Mr. Chairman, that's the problem I'm having. This only comes up in the context of somebody's been assaulted and you have a settlement. At that point, according to what you're saying is, they can have a condition not to tell anybody.
So, Mr. Chairman, there may not always be a settlement, Senator. There may be a scenario where someone isn't really looking to settle, but they'd like to be able to warn a future person coming into the same company that this person is a predator. It allows that person to go public if they so choose.
Mr. Chairman, if there's no settlement, they wouldn't do that. I mean, you either have a settlement or you don't have a settlement. You're trying to split hair somewhere, which I don't see working in real life. I've done these things. I've sued some major employers on sexual harassment cases. We got money, and they stayed on the job. And
So, Mr. Chairman, I think try to explain my perspective on this is not everyone who's sexually assaulted wants to settle or wants to pursue a criminal or a civil claim. They may just want to have the opportunity to state what happened to them without retaliation, and that's what this bill
All right,
allows.
here's where we are. So when I was looking at the introduced summary, this has changed a lot since it was originally introduced in the House to where it is now. This seems to be doing what the summary currently says it's doing and what the patron articulated. It's now a policy decision for us to act on. So is there a motion?
what was the original bill then? I mean,
You can go back and pull up the House version and look at it. It's in a different body. So the motion has been made and properly seconded to report. Any further discussion from members of the committee? Hearing none, clerk, open the roll.
I don't see it does anything. It's like I can't figure out.
Ayes 13, no zero.
Ayes 13, no zero, and that's reported. Thank you very
Thank
much.
you, Mr. Chairman, and thank you, committee members.
All right, Hobie, do you have a list? Where? Ah,
I know.
Delegate Ferris. I hope you didn't bring us a dog bill.
Well, Mr. Chairman, let me tell you, this is some heavy lifting I'm doing here, and I hope everybody
Can
will
you tell
pay
us
attention.
what your bill number is? 1783?
Yes, sir, 1783. It's in Buckingham County. There is a couple there that has some property that joins the state forest, and they travel through the state forest to get to their property on I think it's the Whistlemans are the name, and I think it's a prescriptive easement that they have to get to their property, and they want to get some utilities put in, and with your and the committee's pleasure, Mr. Chairman, we're going to let them do that.
My grandfather grew up in Buckingham County back when there was no electricity and no running water. So I understand why it's a challenge to get these two different places. Any
Mr.
member
Chairman,
of the
there's some
committee
places now that don't have that in Buckingham
Yes.
County.
Any member of the committee have any questions for Delegate Ferris? Motion has been made and seconded by Senator Stewart to report House Bill 1783. All in favor of that motion, please go to the board.
Thank y'all.
Ayes 13, no zero.
Ayes 13, no zero, that passes. Delegate Ransom, we'll go with people here. We did Delaney, Dickie Bell, sorry. Looking at the wrong list.
Thank you, Mr. Chairman. House Bill 2078.
2078, House Bill 2078.
It provides that if a forfeited recognizance is not paid within 150 days, the license of any bail bondsman on the bond shall be suspended by the Department of Criminal Justice Services until that forfeiture is satisfied. The bill further provides that the court will then give notice to any employer of the bail bondsman on the bond to pay the forfeited recognizance within 10 business days. And if such forfeited recognizance is not paid at the end of the additional 10 business days, the bill provides that DCJS shall suspend the licenses of such employer of the bail bondsman or any of its agents thereof until the forfeited recognizance is satisfied. The substitute to the bill removes references to surety companies, and it adds language to allow for license reinstatement if the forfeiture is paid. And it's very specific that the license is not reinstated if another action has caused the license to be suspended.
All right, I see that you might have somebody behind you that are they for you or against you?
Let's hope they're for me. I don't know of any opposition to the bill.
So is that your witness or?
Yes, sir.
Okay, come on up and tell us who you are and.
Mr. Chairman, members of the committee, I'm Dave Bourne, President of the Virginia Bail Association, and we support the bill.
Thank you. Is Supreme Court or DCJS here, and do they have any thoughts? Eileen, no thoughts?
Eileen Longenecker with OES at the Supreme Court. It creates additional process for the clerk's office, but we have no position on the bill.
Does anybody else have anybody from DCJS? All right, anybody else in the public wish to speak against the bill? Is there a motion? Motion has been made and properly seconded to report House Bill 2078. Please open the roll.
Ayes 13, no zero.
Ayes 13, no 0, and House Bill 2078 is reported.
Thank you, Mr.
Thank
Chairman.
you.
Members of
No, he's got it. I don't have Stanley's proxy. I got open chance. Delegate Carr.
Thank you, Mr. Chairman.
Is this 2059?
Yes, sir.
House Bill 2059.
This is a companion to Senator Dance's bill, SB 1667, which makes changes to the grounds for suspension of an individual's driver's license. Not having a license is a barrier to employment and income needed to pay child support. In a 12-month period, the DMV issued 2,676 suspension orders for non-payment of child support. Yes, there's one, yes, sir. So the House courts didn't agree with the expansion, so it's,
All right, Charles, tell us, there's one difference between this version and
Mr. Chairman.
our Delegate Senator Dance's version? Is that accurate?
There are two differences.
Two changes.
On line 47 and on line 61, the House reverted the language back to what is currently in the code so that the person was not given additional time to satisfy the delinquency.
Okay, so our version, we like our version better, is what you're saying?
If you would like to give the delinquent person more time, then you would like the Senate version better. If you want to go with the time periods that are in the code as they are now, then you would stick with Delegate Carr's version. So Delegate Carr's version says that they only get 10 years in which to pay the delinquency. They have to sign an agreement for 10 years to pay the delinquency to get their license back. And for the second agreement, if they haven't paid it off by the first agreement, then 7 years. We had upped those time periods to 15 and then 10 years. Does that make sense?
Well, why don't we do this? Why don't we conform your bill to Senator Dance's bill, and then y'all can have a conversation as this moves through the process. And if y'all come up with an agreement before this gets off the floor, so that'll be today is Wednesday, Thursday. If you come up with agreement by Monday, she can put a floor substitute to flip it back or reject the committee amendments. So maybe we're going to conform it today. You talk to Senator Dance.
All right.
If she likes your version better,
We'll go with that.
then she can make a motion to reject the committee amendments
All right.
on the floor, and it can move through. If she likes her version better, then we'll go to conference and figure it out.
All right, thank
Sound
you.
good?
Yes,
All
thank
right.
you.
Motion has been made and properly seconded to conform House Bill 2059 to the same language as Senate Bill 1667. All in favor of that motion, please signify by saying aye. All opposed, like sign. So that is conformed, and motion has been made and properly seconded to report House Bill 2059 as conformed to Senate Bill 1667. Please go to the board.
Ayes 13, noes 1.
Ayes 13 to Senator Stewart.
Thank
So
you, Mr.
thank
Chairman,
you.
members of the committee.
Mark, come on down. We saved the best for last, right?
Yeah. Thank you, Mr. Chairman, members of the committee. I have two bills. One is House Bill 1656.
1656. All right, I think members, I think we have Delegate Cole's bills and then one other. So if we can pay attention, we can get y'all out to the press so they can.
A few years ago,
I'm joking, clearly. We can keep committee going all night. All right.
All right, a few years ago, we allowed public schools to hire former law enforcement officers in good standing and with the appropriate training as armed school security officers. And all House Bill 1656 would do would be expand that authority to private and religious schools. Some of them have requested to have the same ability as the public schools currently have.
Okay, Delegate Cole, if my notes indicate that right now, public schools hire school security officers as defined under this code section, and currently private schools, which the group you're trying to pick up, hire armed security guards. Is that accurate?
Currently private schools can hire certified armed security guards that have gone through training and been certified by the Commonwealth Private Security. However, what the private schools would like to do in addition to that is have the same authority that the public schools have and hire former law enforcement officers to also be armed security officers.
All right. Is there anybody from DCJS here? DCJS. The reason I'm asking is because DCJS would be the entity responsible for the training and certification of they are currently for school security officers, so they would be in charge for this group of school security officers. But they're clearly not here, wasn't that important to them. All right, any other questions from members of the committee? Bill is before you. Motion has been made and properly seconded to report House Bill 1656. Any further discussion? Hearing none, if clerk will open the roll.
Ayes 14, no zero.
Ayes 14, no zero. That bill is reported.
Thank you, Mr. Chairman. Next bill is House Bill 2278.
2278.
And what this does is it deals with a very narrow part of the code regarding expungement of criminal records. Currently, under Virginia code, if someone receives an absolute pardon because they were actually innocent, they can hire a lawyer and petition a court to have their criminal conviction expunged. This would make that expungement automatic. I think it's kind of adding insult to injury when somebody has been wrongfully convicted and their conviction and they're pardoned because they were actually innocent, to then require them to go hire a lawyer and get that conviction expunged.
I'll help you out. In 2009 and 10, there were 3 of these absolute pardons granted, 2 granted in 15-16, 1 in 16-17, and 4, which y'all would know as the Norfolk 4, in 17 and 18. So over the last decade, there have been 10 of these granted.
It's very rare.
So very rare. This is not it's not opening the floodgates by any stretch of imagination. Motion has been made and properly seconded that House Bill 2278 be reported. All go to the board.
Hold on, if I may, Mr. Chairman.
Oh, sir. Mr. Benjamin.
I understand the policy behind the bill, and it makes perfect sense. I just wanted to make sure that we all considered that if an expungement becomes automatic, then the court records are sealed, and that may mean, there may be situations, if somebody's been wrongfully convicted, they want or need access to those records. And so I'm not certain that doing this automatically is necessarily a good thing. For example, if somebody wants to sue because of their wrongful conviction, or if they want to be more public about it, then all these court records are sealed and they no longer have access to what they might need. And I'm sorry, I just thought of this as you were presenting the bill. So.
would it be possible to amend the bill to allow the defendant or the person, subject of the pardon, to allow them access to sealed court records if they so desire, their own court records?
I have a question is, I mean, there's always going to be a public record if this kind of thing happens. It's a big deal and the person's been pardoned. But the records, expungement's a totally different matter. The policy for expungement is very different than the matter of getting a pardon. I mean, we don't expunge records ordinarily unless somebody was found not guilty.
Yeah.
I know that, but maybe it could be at the request of the defendant. Do it at the request of the defendant.
Again, I think you're getting it, I mean, they can already do it if they petition the court. They can be unsealed. An expunged record can be unsealed. All right, the gentleman's telling me an expunged record can be unsealed.
That's fine then.
It's the next code section.
Okay, excellent.
But,
Thank you.
Mr. Chairman, why wouldn't we keep it the way it is? You're found not guilty, it's like the governor's pardoning you, and then you go to court to get it
Well, like I said, what you're doing is forcing an innocent person to hire an attorney to petition the court when they were wrongfully convicted to begin with.
All right, we're going to move back. Senator Stewart moves, Senator Reeves seconds that House Bill 2278 be reported. Any further discussion from the committee? Hearing none, please open the roll.
Ayes 14, no zero.
Ayes 14, no zero. Thank you.
Thank you.
All right, we have one more, and that is House Bill 1787. So, what, can you tell us what the difference is?
Mr. Chair, the difference between this bill and your bill is on lines 153 and lines 154. Your bill had the long cross-reference to 18.260. This bill just shortens it to a threat pursuant to 18.260. So it strikes out the entire title. It says threats of death or bodily injury to another person. It just shortens it. That's the only change.
So what's, I guess y'all drafted both of these versions, or what is the better way for us to do it, the long version or the short version?
The long version's probably more consistent. If you look at like robbery, it just says robbery pursuant to, doesn't go into the full title
Okay.
of robbery, so the short version might be more consistent.
Which version?
The short version might be more consistent, so.
Okay, so we want to go, so you're saying the short version is the way we should go?
Correct, Mr. Chairman.
All right, so we want to leave it the way it is?
That's correct, Mr. Chairman.
All right. Any questions for Charles? That, Commonwealth's Attorney, do y'all like the short version? Yes, sir. All right. They like the short version. Senator Pink moves, Senator Stewart seconds that we pass the short version of HB 1787. Open the roll.
Ayes 14, no zero.
Ayes 14, no zero, and the short version is passed. Is that, we have one? Who? Okay, where are they? Okay, where are they? Let's look at 2464. Okay, 2464. $24.64.
And Mr. Chairman, while they're pulling that up, what do we do with this confidential stuff from the Supreme Court?
You leave it here.
Just
and
leave it right here?
And somebody will take it away and make sure it stays confidential.
Shred it. Thank you very much.
All right, so Charles, if I'm looking at 2464, this was, we had a version of this last year? No, was was the open change bill this year. This was a portion of the bill that passed out of here at 14-0, but this was a portion that has no physical impact because it only applies to the two-way video closed-circuit testimony. And this says that if the victim is age 14 or under at the time of offense, or 16 or under at the time of trial, then they can testify by video. And if a witness is 14 or under at the time of trial, so we're giving a little more latitude for victims to be just a little bit older.
Mr. Chairman, Colin Drew with the Crime Commission. The language in the bill keeps the current ages as they're set in the statute. The statute sets the ages as 16 or under for the victim, and 14 for the victim, 16 for the witness. It does not change the current statute. It just adds commercial sex trafficking offenses to the statute. There are other offenses that are authorized for that testimony as just adding commercial sex trafficking offenses.
Charles, this doesn't cost us any money either, correct?
That's correct, Mr.
So
Chairman.
it does not need to go to finance?
That's correct, Mr.
All
Chairman.
right. Does anybody have, any members have any question? Prosecutors, y'all, College attorneys, thumbs up from them? All right, motion has been made to report, thank you, Colin. Made to report House Bill 2464. Go to the board.
Ayes 14, no zero.
Ayes 14, no zero, and that is reported. So what'd it say again? 2659. Draw your attention to House Bill 2659.
Mr. Chairman, House Bill 2659 deals with bail bondsmen and them essentially posting a amount of bond if they need the court to issue a capias. Currently, bail bondsmen can surrender people to the court by two ways. The first is obviously if they bring them back themselves, and the second is if they ask the court to issue a capias. So this bill provides that when the bail bondsman seeks the court to issue a capias for the surrender of a person, that he will have to post 10% of the amount of the bond or $50 when he makes that application for the capias.
All right. Eileen, Supreme Court, did y'all look at this one?
Eileen Longnecker with the OES at the Supreme Court. We have no position on the bill. We can implement it as is. The only issue I raised with staff is that whether there's an inconsistency in the first sentence. And again, we don't have a position on the bill, but lines 29 and 30 talk about if the bail bondsman surrenders the principal for any reason other than a summons to show cause. And we read that to be both just surrendering the person or the other way of asking for a capias. And then the language continues saying they have to pay the money, and the money shall be paid, line 32, at the time the bondsman makes application for a capias. So again, we can implement the bill as is because it'll simply be the clerk accepting any money when a bondsman comes. But we raised a question as to whether that first sentence is inconsistent.
Mr. Chair, I did talk to the patron about this concern, and the patron's intent is to only have it apply for when the capias is applied for, because if the bondsman has the person and surrenders the person to the court, it seems it would be unduly penalizing the bondsman to require him to post a bond when he's returning said person to the court.
Okay, so what language would fix that?
Well, he would resist any amendment. The patron would resist the amendment that the court is suggesting because he feels the patron feels it's unnecessary. I do, however, have an amendment that would, if the committee would like to move forward with an amendment to take the court's consideration, basically the amendment would read on line 32 after the word capias, we would insert or surrenders his principal to the court. So that would cover both situations. But again, I know the patron would not be in favor of that amendment.
Okay. All right, so here, I think what I'm gonna do is take the temperature. If we want to move forward with just the capias language, we'll take a vote now. If somebody wants to move forward with the amendment, I think we need to wait for the patron. Does that sound right? All right, so that if somebody wants to move forward, they need to make a motion. This motion has been made and properly seconded to report House Bill 2659. Any further discussion from the committee? Any conversation, y'all are okay with the way this, y'all like it the way it is? Yes, sir. Okay. All right, with that, committee will vote.
Ayes 14, no zero.
Ayes 14, no zero, and that reports. So is that all we have? And Senator Reeves, you took care of your issue, and thank the committee and thank the team for y'all's effort in trying to make sure we're staying straight. It is always a little more complicated when they're House bills to make sure that we're consistent. So with that, the committee will rise.